Okay, dear guests, if everyone can take their seats. Nee, we hebben denk ik zo'n... Oh. Okay, just wait another minute so that people can take their seats, and then we can start with the last session of the day. Okay. All right. Well, so I think we are all ready to proceed our program. Yes, okay, I think we can start our program again. The last session on confidentiality of lawyer-client communication. Is there a need for greater protection? And this panel will be moderated by the CCBE First Vice President, Pierre-Dominique Schupp. Thank you, Schupp, for joining us. And he will be our president next year, if everything is going fine today, of course. But I have no doubts about this. In addition to being a valued member since many years within the CCBE, but also within the Swiss delegation, he has a long-standing career as a lawyer, more than 30 years, mainly in civil liability, commercial law, and white-collar crime. He has presided also the bar of the Canton de Vaud and also served as president of the Swiss Bar Association. Dominique, the floor is yours.
Thank you. Can I say Cuomo? Thank you, Simone. Ladies and gentlemen, this morning, I think it was during the first panel, somebody raised the question on why it is so difficult to have the importance of the role of lawyers be recognized or simply to be as lawyers are. Indeed, the central role that the professional secrecy is playing for the profession is maybe one of the explanation. To the notion of secrecy is attached some kind of mystery when we do not talk about lack of transparency. This may maybe explain why it is unfortunately a mere fact that the professional secrecy of lawyers, I prefer always to say of citizens, is suffering stronger and stronger attacks. And in order to discuss whether confidentiality of lawyer-client communications need a greater protection, we have today the great chance to have here three panelists who have a very deep and extensive, I would say even practical and personal experience in this field. You will probably talk about that later on. First, I'd like to welcome, on my right, Marc van der Woude. I hope I pronounced that correctly. More or less, sorry. President of the General Court of the European Union. He started his career as a tutor at the College of Europe in Bruges and as a lecturer at Leiden University just after I had the opportunity to spend 1 month in Leiden in 1984. You were there a little bit later. He then joined the European institutions where he worked for DG Competition, followed by the European Court of Justice as a legal secretary and the Commission's legal service. He then became a member of the Brussels Bar, where he practiced European competition law for 15 years. Marc van der Woude, better? Woude, sorry, is still professor at the Erasmus University of Rotterdam, is an author of numerous publications on European and competition law. He is particularly qualified to provide a unique perspective on the importance of lawyer-client confidentiality. Mattias Guyomar, juge à la Cour européenne des droits de l'homme. J'ai même pas besoin de le...
Mattias Guyomar, who's a judge at the European Court of Human Rights. I don't need to introduce him. He introduced or presented himself this morning. You are a judge. You were elected on behalf of France, au titre de la France, it says, thus elected on behalf of France in June 2020 in Strasbourg. Mattias Guyomar's experience is in public law. He has also taught public law in 2 different universities in Paris or in France. And before being elected in Strasbourg, he was member of the Conseil d'État between 2018 and 2020. And of course, Conseil d'État also deals with so-called public liberties, which gives him a particular competence to deal with the issues we're discussing this afternoon.
She has been CCBE president in 2021 with a particularly extensive career in criminal and compliance law. Her background as a lawyer and involvement in various bar associations, as well as being a judge at the Constitutional Court in Berlin, places her in a unique position to discuss the vital role of lawyer-client confidentiality. Please join me in extending a warm welcome to our esteemed panelists. I will first give the floor to Marc van der Woude. At the end of the afternoon, I will get it for your remarks.
Thank you very much, President. I'm very pleased to be here at the CCBE to meet former colleagues and friends. And it's also particularly, important to me at least, to speak about professional secrecy on legal professional privilege. It's an issue which I worked on for many years as a private practitioner. Legal professional privilege is essential for the rule of law. I think defending the interest of your client before courts in all confidentiality, also giving advice, is part, say, of the common legal traditions and is now enshrined in the Charter, both under Article 47 as regards, the fact that you can plead in all confidentiality with the trust of your client, but also to give advice under Article 7 of the Charter, which mirrors, in a certain sense, Article 8, but I'm sure that my colleague Guyomar will say more about that. So important elements that are threatened, if I understand. You wouldn't have organized this session if there had been no issue with legal professional privilege. I read an article recently by the president of the French bar delegation here in the Journal of the French bar delegation, Monsieur Petiti, in which he lists a series of elements which are quite indeed worrying. Attempts to weaken the scope of legal professional privilege to only judicial proceedings, or the clash of professional secrecies, saying that we are officials, we are also covered by secrecy obligations, so don't worry, your secrets are safe with me. That type of argument. Or simply searches in lawyers' offices, or overhearing telephone conversations. So the situation is grim, according to that article. Moreover, there are situations, of course, in the digital world which make it more complex to defend legal professional privilege than in the brick-and-mortar world as we knew it until now. I will make 6 points this afternoon, if the President so allows me, because I don't know exactly how long this will take me. But now I'm a judge and normally can speak as long as I want, so that was not the case when I was a lawyer. So please cut me short if need be. First, I will say a few remarks about where LLP comes from, how it evolved in European law, first in the competition law area, then in the broader area of European law. Then a third point on how to make it operational. How do you work with the principle of legal professional privilege from a practical point of view in investigations, in particularly investigations by the European Commission? And then the fourth point, what happens if things go wrong? What are the consequences of the violation of professional secrecy? What happens to the evidence? And then the fifth point, and that's perhaps a bit hors context, which concerned my wish for the opposite of legal professional privilege. And I see you now a bit puzzled, but when we'll come to it, you will understand what I mean. And then some concluding remarks, and I hope I will have time for that, but we will see. First, the origin. The origin is old, at least from a European perspective, because the whole European construction exists only for 70 years, but the issue surfaced in the 1970s during an inspection carried out by the European Commission in the famous AMNS case. And there the court found that the privilege principle belonged to the common traditions of the member states. So it is something which is common to all our legal traditions that, say, independent lawyers, because that was one of the elements of the case, can give advice to their clients and defend their clients to the best of their interests. It was specified, of course, and that's a bit of a delicate issue, it must be independent lawyers registered with a bar in the union, or the EEC as it was called at the time. That principle was repeated in 2007 and in 2010 in the AXO case, in which these principles were confirmed by the General Court and the Court of Justice. There are some interesting points in that AXO case. First, as to the ratione personae. It's only independent lawyers and not in-house lawyers. That was one point. The second point was that the court clearly confirmed that the privilege not only applies to the documents which the lawyer has made, but also the correspondence which the client made to feed the lawyer for its defense. It's also those documents which are created for the purposes of having sought external legal advice. And then a third point on the procedure, but I will come back to that later. So those are basically the key elements of legal professional privilege in European law, and in particular in European competition law. So that was my first point. But things evolve. Professional secrecy is not only an element which concerns competition law investigations, but also happen in other contexts. There have been developments in the Strasbourg case law, of course. My colleague will talk about that. And there are developments in the member states, in particular as regards the scope of the personal scope of legal professional privilege. The very rigid approach taken by the Court of Justice in the AXO case, and now you will feel that I'm not completely objective when I talk about legal professional privilege, having been one of the lawyers involved in that case, before I became a judge, of course. The scope is now changing in the member states. Also in the case law of the Court of Justice itself, for example, things are changing for the moment when it comes, for example, for the possibility of, say, the concept of lawyer allowed to plead before the Court of Justice. And that judgment, say, the case law is now in a state of flux, and it could well be that it has also an impact on the personal scope of legal professional privilege. But more importantly, two cases which I would like to mention outside the scope of competition law. The first case concerns the Belgian bar associations. In fact, the Belgian bar has been very active in defending the principle of professional secrecy. And the first case dates from 2007. It's all the bar associations of Belgium, which protest before the Belgian courts concerning a law which implements a directive, the money laundering directive, which imposes an obligation on external lawyers to inform the authorities of the possible events leading to money laundering. The Belgian judge requests the Court of Justice to give some clarification about the scope of the protection by the directive. And it's very interesting to see that in the answer given by the Court of Justice to the Belgian judge, the Court of Justice focuses on Article 6 of the Convention, so fair trial. And it explicitly rules out Article 8. I think that's important when my colleague will speak about the Strasbourg developments. So Article 6, the principle of fair hearing, the principle of fair trial, but not the advisory sphere which is linked to the privacy requirements of Article 8. The Court of Justice validates the fact that the directive imposes duties to inform the authorities of money laundering transactions. First, because of the fact that it only covers a limited set of transactions. That was one point. And secondly, because it didn't affect the right for the lawyer to help and assist its clients in the context of judicial proceedings, for preparing them, carrying them out, and informing them afterwards. So that was one important element which the Court of Justice took into account to consider that there had been no violation of the Charter, at least of the common principles of the member state, as enshrined in Article 6 at the time, in 2007. It more or less mirrors the Michaud case, and my colleague will speak about that, on Article 8. There, the Strasbourg Court didn't focus on Article 6, but on Article 8. So both cases, the 2007 case of the Court of Justice and the Strasbourg case, in a certain sense, complement each other. Then, fairly recently, in 2022, come the Flemish lawyers complaining about another directive, a directive which also imposes a reporting obligation as regards aggressive cross-border tax constructions. And it's a complex case, because if there are tax constructions, you have several intermediaries which can be involved. And the legislator took into account that sometimes these intermediaries can be lawyers, and that lawyers which invoke a legal professional privilege have an exception and don't have to report. However, they don't have to report directly to the tax authorities, but they must inform the other intermediaries, which on their term have the possibility to inform the tax authorities. So it's an indirect reporting obligation. And on that point, the Court of Justice considers that the directive is invalid. And the interesting element there is that it is Article 8 of Article 7, of the Charter, and not Article 8 of the Convention. And the Court of Justice specifies that the existence of the advice itself must be kept confidential. So that's, I think, a major step forward, in particular if you compare that with the 2007 case which I just referred to. So where does that lead us? I think legal professional privilege since that Flemish case has been improved. We know that legal professional privilege, when it comes to judicial proceedings, is the hardcore. That's an area where you can't go. When it comes to the advisory role, I would say it depends. It depends. Are we dealing with hard crime, or are we dealing with aggressive tax constructions? I think there is a balance to be made. I think if you speak about money laundering, people say, no, we need to know about it. If aggressive tax constructions provide that they are legal is another thing. So it is, I think, a question of safeguards and of balancing which the courts will make. So that was my third observation, as the second observation as regards the evolution of the case law. Then a third observation on how to make LLP operational. And there I come back to the 2007 AXO case, which was dealt with by the General Court at the time. It said that documents which are protected by legal professional privilege must be kept out of sight of the authorities. That's an absolute principle. Of course, sometimes it's clear. Well, it's clearly said on the document, it's privileged, so you put it aside and it has to be discarded. Sometimes it's less clear. If it's less clear, the document has to be put, and we speak about 2007, in an envelope. And then a decision must be taken by an independent person, for example, the hearing officer, and that decision can then be challenged before the court, before the document can be used. So, prior judicial review before the use of the document. So that's an important element to safeguard that legal professional privilege exists. I submit, although there's no case law which confirms this, that the same would apply in the digital world. Now, you can reproduce the envelope procedure digitally. I think you can find elements to that in the Nexans case, in the Meta case, which dealt with inspections and requests for information. I think you can reconstruct a safe environment in which documents can be put before they are disclosed to the prosecuting authority. But here I would like to make a point, because if we see, for example, now inspections and requests for information, they're essentially done by machines. They absorb huge quantities of information with very broad search terms. This is validated by the Court of Justice for the moment in the Meta case. There's nothing wrong with that. But the broader it gets, the easier it is that you absorb legally protected documents. And it's, I think, important for the legal profession to clearly mark documents as being protected and to take safeguards that there are no errors. Because if the error is made, the genie is out of the bottle and then it is too late. Especially since there is case law which gives an indication that as soon as legal professional privilege is waived, if you don't insist on it, it no longer exists. So that was my third point. The fourth point concerns the consequences. What happens if, nevertheless, the authorities, the prosecuting authorities, find or have access to privileged documents? There again, there's no clear case law to it. The EXO case law is pretty clear. It says documents should not be seen. But errors can happen. And then again, of course, you will have a lawyer's debate about what the scope of the consequences is. The whole theory of the fruit of the poisonous tree will then occur. And I think that's essentially, I would say, a factual matter which depends on, what type of procedure are you dealing with? What is the type of law? What are the interests at stake? And who is relying on those documents? Is it something against the client, for which the document was made? Or is it vis-à-vis a third party, which can also be a scenario? As I said, there is not yet clear case law on this. We have some case law dealing with illegally obtained evidence, which shows that the Court of Justice has a relatively open mind as to the use of, I would say, illegally or not regularly obtained information. The first case is the Web Mind Licenses case of 2015, where we see tax authorities using evidence obtained in criminal proceedings, whereas these proceedings were not yet finished. And there, at the end, you see a typical balancing test. And I'd say, you parties must have been heard about the information. We want to check as a judge what were exactly the consequences in which this information was obtained. So it's a bit a balancing test. The same occurred in the Goldfish case. It was also a balancing test. And I think we will see what happens if one day we get an issue concerning the consequences of a violation of legal professional privilege. But what I would like to submit is that in any event, documents which are privileged can never be used against a company or a client. What then the consequences are for the legality of a decision depends on the facts, and in particular on the question as to whether there is other evidence which supports the claim of the authorities. So that was my fourth point. Now a brief point on the opposite of legal professional privilege. I'm looking at the president of your association, and he will know what I will be going to say, is that, of course, legal professional privilege is something where you don't want the authorities to see the information which you have with your client. But there are sometimes settings, and I'm pleading for my own court, where we would like to have the lawyers see information which the clients should not see. Because in front of my court, we have lots of cases dealing with complex, confidential matters. And sometimes the legal debate before our court is so complexified by confidentiality issues that we would like to include as many lawyers as possible in confidentiality rings, which is basically the opposite of legal professional privilege, because it implies that the lawyer shares information with the court and the other lawyers, but doesn't share it with his clients. So I think that's an element in this particular speech which I would like to mention as well as the opposite of it. And I would like to invite your association to see how it can contribute to the proper functioning of courts in making perhaps standard arrangements or things which would facilitate the practical functioning of courts in this respect. But I admit that this observation is a bit hors sujet. That leads me to the last observation. I'm still looking at the President. He is still allowing me perhaps 30 seconds. On the concluding remarks on legal professional privilege. As I said in the beginning, it's a principle enshrined in European law. It's in the Convention, it's in the Charter. I think it has its hard core when it comes to the participation of lawyers in judicial proceedings. When it comes to the advisory role, we have a bit of it depends type of situation. What is the type of law at stake, and what are the procedural safeguards? Now coming to the question, is there a specific need for additional protection? Because that's the theme of this conference. Quite frankly, at this moment, I don't see from a European point of view a direct need for increased protection. I see increased dangers, in particular in the digital world. And I see, in particular, a need to identify more clearly legally professional or protected documents to make markers that they are not absorbed by machines and that they can be kept as confidential. So those were the few remarks I wanted to make, and I thank you for your attention.
Monsieur le Président, vous avez trouvé moyen.
Mr. President, in 15 minutes, you've managed to really set the stage in quite an incredible way and with a lot of clarity regarding legal professional privilege. Thank you for that. Maybe we'll be able to come back to a few points. Maybe when I was a bâtonnier, when I helped a colleague, or I was helping the police because it was too complicated to copy the hardware of someone. I was helping during a search. Yes, of course, we can put a hardware in an envelope, but how do we extract information afterwards? This might be a bit more complicated. I will now give the floor to Mr. Judge Mattias Guyomar, who had his coffee in between. So I reckon you're perfectly fit now to tell us more about case law at your court, the European Court of the Human Rights. Yes, thank you, Mr. President. Indeed, I just had a coffee and I must talk now. So I'll first start with the opportunity to speak, to just thank everyone to have offered to the European Court of Human Rights to take part in this debate. I represent the President O'Leary, who gave me the honor to represent the European Court here. And since I arrived this morning, I realized how important this debate here. We already had the opportunity to mention this, but also among all institutions, not only among lawyers and judges. So really big thank to you. Since this morning, we've been stressing the essential role played by the lawyer. The principles underlying the effectiveness of the protection of the rights and freedoms recognized by the European Convention on Human Rights, namely the accessibility of the rule of law, the foreseeability of its implementation, and the possibility of having compliance with it reviewed before the court, require the intervention of the lawyer, without whom I have always pointed out that the realization of rights is not conceivable.
Dans cette perspective,
in this perspective, it is clear, in view of the Convention, that the lawyer is not only a subject of law who, like all the holders of the rights enshrined in the European Convention, deserves protection, but is also a crucial player in the system that grants all persons such protection. In other words, the lawyer is protected not only for himself, but also, given his role, by virtue of his mission, placed at the service of the other holders of rights. By fully exercising his role, he constitutes a condition of the right to have rights. If we look at the case law of the European Court of Human Rights, we can see two things. And it is always resorted to in individual situations. So here are the two things we observe. On the one hand, there is a wide variety of situations in which the integrity of the mission of a lawyer is called into question. We talked about this morning: seizing data, tapping phones, intercepting phone conversations and correspondences. There are many cases, so that's the first observation. On the other hand, and this is the second observation, every time this strength and protection intervenes to protect the relationship between the lawyer and the client, this applies to the lawyer, yes, but also to the client. And so this is a conventional protection by ricochet. The cases decided by the European Court that call into question the role of the lawyer most often, directly or indirectly, challenge the place that the lawyer must be able to occupy in a state of rule of law as the guarantor of procedural and balances. And this is linked to the relationship that he maintains with the person he is advising or he is defending. This relationship of trust guarantees legal professional privilege in the in a decree of 2008, where the court marked that the legal professional privilege is a precondition to a relationship of trust. And in a more bilateral way, there is the confidentiality of exchanges. So these are the two bulwarks both the lawyer and their client must benefit from. Regarding protection standards we can find in our convention, there is Article 6, of course, the respect to the right to a fair trial, especially when it comes to criminal cases, the right to have a defense with paragraph 3, line C, the right for any defendant to defend themselves or to be helped by the assistance of a defender of their choice, and if they do not have the means to remunerate them, to be assisted free of charge by a lawyer when the interests of justice require this. However, we must look beyond Article 6, as this is the most famous article. We also must take into consideration Article 8, which protects non-jurisdictional configurations, the relationship between the lawyer and the client, usually on the grounds of privacy, and the privacy of the correspondences between both. And very rapidly, the court recalled that the relationship, the lawyer-client relationship, when it is governed by a legal instance is part of private life. And the goal is to enable any individual to make informed decision regarding his or her life. And since I'm talking of Article 8, 6, and 8, I would like to talk about the complement nature of the protections provided by these two articles of the European Convention. On the one hand, thanks to these two pieces that match like in a puzzle, they guarantee a continuum of protection which comprise all the modalities of the legal profession, legal assistance, advice, and even defense. And thus, the lawyer is completely protected in his function. And as such, his entire role is taken into consideration beyond the simple trial, the role as a guarantor, allowing the access to law and allowing individuals to benefit from the law. So this is how these protections dovetail. And then the second complementary aspect is about the holding of the rights. The Constitution protects the client-lawyer relationship from the point of view especially of the client, but Article 8 protects not only the client's right, but also those of the lawyer. And so we move from puzzle to Russian dolls because one encompasses the other. This complementarity in protection takes us back to the double dimension of the case law of the court about this cardinal relationship between lawyer and client. Furthermore, the lawyer and the client are protected on the micro scale in the sense that defending the individuals are part of a democratic society. But then there is a more structural dimension which is beneficial to the rule of law in a systemic way. I mean by that it contributes to guaranteeing rights, and it's also a condition. And the Campbell Decree in 1992 against the UK, in this decree, the court recalled that this is a matter of public interest, that a person who wants to turn to a legal expert should be able to do so in conditions propitious to a free and full discussion. So there is public interest at stake. This relationship between the client and the lawyer has to be structural and functional and enjoys protections. Now, if we take a look at the level of protection, well, if we take the court's case laws, we can say that this level is high without being absolute. After there are no more remedies, and to respect the principle of subsidiarity, the court always makes sure that rights violations do not have an impact on the substance of these rights to guarantee the full compliance of these rights. A protection which is high thanks to its extent, and this can be demonstrated by the wide scope of the notion of correspondence, which, according to Article 8, was protected whatever the objective and whatever its form. The content of the communications has no impact on the protection it should enjoy. In the Campbell ruling, the court clearly explained that there was no need to make a difference between the different categories of correspondence with lawyers, whatever the objective, because the court explains the limit between a correspondence, a general correspondence, and another type of more complicated correspondence should not be considered. I think this is important. Now, when it comes to the form of the exchanges, the nature of the exchanges, the court has a position on this as well. In the decree Laurent against France, a lawyer gave his phone number to a client, and this is a protected form of correspondence. So whatever the form, this is the materialization of this relationship that it counts. And Another example is, regardless whether the communication is written or spoken, this applies to both as well. And we can clearly see that sometimes during a discussion, sometimes a haste discussion, essential information can be exchanged. Articles 8 and Article 6 are therefore intertwined, and I believe it is important to bear this in mind. I gave 2 examples with Article 6, and I will give another one now, which illustrates the wide spectrum of situations that are protected. Regarding Campbell, this was a situation regarding freedoms. Very well known ruling is Beuze against Belgium. This was in 2018. This is very interesting for this topic today, because if you take Article 6, and when it comes to prisons, the court said that a detained person should be able to communicate with his lawyer without being heard by others, so that the detained person can discuss freely what they want to discuss, but also so that they can flag any abuses that were committed against them without any fear of reprisals. So I believe that this also illustrates the wide protection that is granted to the client-lawyer relationship. So a high degree of protection, yes, but this is not indefinite or absolute protection. Now, you said it earlier on when it came to money laundering. There are restrictions that have to be brought to professional secrecy or to correspondences. And the court acknowledged that this relationship, the protection of this relationship, has limits. And these limits are strictly governed. And this is the second part of my presentation. First of all, and it's important to bear this in mind, to ensure that the implemented restrictions do not reduce the substance of the law, depriving it of any efficiency, the court must see whether the limitations are foreseeable. So that's the first step. And then second step, is there a legitimate goal? And this takes us back to paragraph 2 of Article 8, the reserve clause. And third step, whether they are necessary in a democratic society. So this takes us back to the principle of proportionality. And I'd like to really highlight these 3 steps I've just mentioned. So there is the quality of the legal basis. Does the interference have a legal basis in terms of quality? Is the goal legitimate? And third, is the interference necessary? As part of this, the court decided that the margin of appreciation the defending states enjoy to define the admissible limits of interference in the confidentiality of communications with lawyer was quite narrow, and only exceptional circumstances, such as trying to thwart a serious offense or something of the sort, could justify this. And we can see in the Altay against in the Altay against Turkey decree of 2019. And so this really demonstrates the high level of requirements of our case law. And I would like to say that there are many violations of Article 8 when it comes to the client-lawyer relationship. There was one ruling in 1990 with Switzerland. It was a decree on the tapping of telephone lines of the applicant's law firm. The Attorney General of the Confederation noticed that Article 8 had been violated because Swiss law did not indicate with sufficient clarity the scope and manner in which the authorities could exercise their discretion in the area in question. In the Niemetz versus Germany judgment of 16 December 1992, the court found a violation of Article 8, which was also at issue in the context of secrecy of correspondence. And this offense wasn't minor. It had justified a search. A judge had been put under pressure. There was an attempt to pressure a judge. And this was a serious case, of course. However, because of the terms of the mandate that were too wide, too broad, which requested the seizing of documents without any limits, and furthermore, there were no specific guarantees for the procedure, including the presence of an independent observer, but we can come back to this later, which could be a bâtonnier. And so the mandate was too broad and there were no guarantees for the procedure. And last example of a violation, and I already talked about this, André versus France in 2008, that recall that the term home in Article 8 could include the office of a member of a liberal profession, and a visit to the applicant's chamber was made and seizures were made, and the court observed a violation of Article 8 because of the disproportionate nature of the seizures compared to the goal of these seizures. And this takes us back to what our president say regarding the possibilities. Despite the contestations of the bâtonnier, which was present, he was not able to prevent the consultation of all the documents of this law firm, including private documents which were protected by secrecy and which had nothing to do with the fraud suspicions which had justified this home visit. And now a few words on the restrictions and their possible criminal justifications. And we'll be moving to Article 6 for this. And we'll be talking about the modalities governing the exchanges between a detainee and their lawyer. Sakhanov versus Russia. There was no restriction applying it to the relationship between the client and the lawyer, and no limitations must create an obstacle to an effective trial. So there are many situations, for example, when a phone is tapped, or when a video conference is being followed, or when the interviews are being monitored, etc. There are cases that affect the 46 months that ratify the convention every month, and this no longer affects Russia, which was expelled since then. But however, this happens every day, and every time the court recalls that it's only in exceptional circumstances that the state can limit confidential conversations of an accused person, of a defendant, because it says in the Galen versus Turkey decree, the communications between a defendant and his or her lawyer can only be admitted for valid reasons. So what is a valid reason? So regarding conversations out of earshot. This is also a very difficult balancing act. So there are also risks of collusion and problems that can be linked to the ethics of the lawyer, risks to security, and other imperious reasons linked to public security, which you can probably imagine. But every time the court ensured that the procedure was fair, meaning that this restriction did not have any impact on the trial. I will conclude with the Michaud ruling we mentioned earlier on. The president mentioned this. This ruling this judgment from the State Council of 2009, and back then when I was a member of the State Council I had taken part in it, and it became a decree of the European Court in 2012. It's a very important judgment. Now, I won't quote it because it's dozens of pages long. However, it really nicely summarizes our case law on the importance of legal professional privilege and the functioning of justice and so on. It's one of the main principles the justice system in a democratic society should hinge upon. And this issue, when it came to suspicion as to money laundering, was then covered by the European courts. And it takes us back to Article 8, whether there is any interference into the relationship of trust. The European Court admitted that this mechanism is compatible with Article 8 by highlighting the importance of the interference in its reasoning. So first, the court, after the 2009 ruling of the State Council, that the declarations of suspicion are not linked to the lawyer's mission, which is to defend its client, and which is part and parcel of the which is protected by secrecy. And then secondly, here we're not talking about the direct communication among lawyers, but rather the information that is sent to the bâtonnier, for example. And so this is a guarantee that had not been present for many cases in the past, which is now being implemented with this case. I just wanted to close with this ruling. One last point.
L'Office de la Cour européenne.
This is very interesting if you take into consideration the Office of the European Union. Now, this is a case where you have a conflict between the fundamental principle, that of the legal professional privilege, and the confidentiality of exchange of communication. And then you have a general interest, which is in fact in competition with this. Now, you have to take into consideration the finality. Have the restrictions followed or respected a legitimate goal or not? So it's a sort of subsidiary control which tries to regulate as much as possible the action of the court. We're talking about a balanced management between the judges at internal level, and the Conseil d'État has actually observed on several occasions that there was no problem with the shared responsibility between the European Court and the internal issues. In fact, the European Union was actually implemented correctly. There was the European Court which did not take into consideration the protection provision from the Bosphorus judgment, but generally speaking, following the same approach, the same result was reached based on the guarantees provided through the European legislation itself. And I'd like to end by noting two things which are the most important things to say in this regard. And it actually highlights the lawyer-client link, the fact that the rights that are being protected are considered as saint, and we have the protection of the defense mission from a procedural point of view, the role of the chairman or president of the bar, which is an intermediary which is above any suspicion. This is something I wanted to present. Thank you very much for your attention.
Je vous remercie infiniment, Monsieur le Juge, pour ce.
Thank you so much, Judge Guyomar, for this fascinating presentation about the legal professional privilege and the comment you just made about the role of the president of the bar. I mean, very recently, I was faced with the president of the Zurich bar. That's the largest bar in Switzerland. And he asked me if I was the one who acted as an agitator because somebody had actually put forward the need for the president of the bar to be present in a search. And he said that as long as he were to remain the president of the bar of Zurich, he is not going to interfere or be present when a search is actually made at a lawyer's office. I'll now give the floor to Margarete van Galen, and she will actually give us her insight on the legal professional privilege in her view. Thank you very much. You have the floor.
So for these very interesting, surveys on the case law and the borders also you describe, and also the borders for the lawyers' confidentiality, lawyers' clients' confidentiality principle. And I think my role is to question these borders as well. We heard a lot of balancing, and just to give you an idea where I will head, I'm really wondering whether this is a principle which bears balancing. So let me first just reiterate, it was already mentioned, what this privilege means in reality, what it means for the citizens, for the legal persons as well. It's not only vital for upholding the integrity of the legal system, but also for safeguarding the rights of those who are in need of legal advice. This is what was stated also recently in the last decision by the European Court of Justice. And I think it's important to point out that the legal privilege should not be considered, not only or even not at all considered as a right of the lawyers, but as a right of the clients when they exercise their fundamental rights of seeking legal advice, defending themselves against accusations, or challenging issues before the courts. And for the legal profession, I would say the professional privilege is less a right than a sacred responsibility. This responsibility is also mirrored in national law of the member states, where the infringement of confidentiality is sometimes considered as a criminal offense or at least as a sanctioned offense. And when clients have the assurance that their communications will remain confidential, they are more likely to provide all the necessary information, even the most sensitive details. And it prevents a situation where clients might be deterred from seeking legal advice due to concerns about exposure or to admit possibly illegal behavior. Only when clients can trust their lawyers 100%, lawyers will not only be able to ensure a high quality of legal advice, but also be able to prevent clients from acting against the law or even committing a crime. So I think it's very important to see also this side of the medal. We always hear, well, we have these issues with lawyers who might have or who are accused of having helped clients by behaving illegal, but there is a big gray zone where lawyers prevent clients from acting illegal, and this is only possible if there is really 100% confidentiality. And of course, as we all know, it's not an absolute right. It is, and I think it should always be, subject to the limitation that the privilege does not protect communications or materials that are made in furtherance of a crime. And this exception ensures that the privilege is not misused to shield legal activities. The legal professional privilege is a fundamental aspect of our justice system, and it upholds the principle of trust, confidentiality, and justice. And my question really is, can this be balanced? Can this be balanced by safeguards regarding the procedure? It was spoken about the conflict between this right and the interest of the state to go after important issues. And although I know the European Convention on Human Rights, they provide for balancing. It's in the law, in the existing law, but we have this question mark today. And my question would be, is this really necessary? Do we have to balance this, or wouldn't it help the legal situation, the rule of law, if we stopped balancing this and just had this limit, which is in the law and which should always prevail, that if lawyers are suspected of being involved in a crime, then of course this principle is no longer applicable. And in this atmosphere that of balancing and of the right to balance this and to see whether the right is more important than the interest of the state, of course, there are developments which are worrying. Several national bars have stressed that the preservation of professional secrecy is more and more endangered in a digital environment. We already heard about this, and I think digitalization leads to two issues. The digital development produces new technical possibilities for surveillance. There is mass surveillance, and whether by state agencies or private actors, and this has the potential to intercept and monitor communications between lawyers and their clients. And the second point is digitalization facilitates the access to information. And this gives rise to supposed or real needs of law enforcement authorities for access to data they deem important for their cause. And I think the e-evidence regulation, which does not provide enough safeguards regarding the protection of the legal privilege, is a good example for this development. There is the need to easily and with high speed get access to documents, and then suddenly you don't have the time to establish the right safeguards for the legal privilege. Apart from challenges by the digital development, bars and law societies have voiced concerns about the recent trend to question the scope of professional secrecy and the attempts by public authorities to differentiate between the different activities of lawyers, considering that the advisory activities of lawyers might be not covered by the professional secrecy. In France, legislative changes were introduced which, according to the French bar, do not fully implement the guarantees provided by existing law and disregard the principle of indivisibility of professional secrecy as guaranteed by the case law of the Court of Justice and of the European Court of Human Rights. The Estonian bar reported the problem of a lack of regulation regarding the search of law offices and the inconsistency of the practice of courts and prosecutors in their country in this regard. The Belgian bar provided the example of visits of fiscal control authorities who sometimes consider that confidentiality of a lawyer's correspondence is not applicable to them due to their own professional secrecy rules. The Slovak bar mentioned repeated flagrant breaches of the procedure that governs searches of law offices. And in the Netherlands, there is a legislative proposal that intends to enable visual supervision during the visit of a lawyer to high security prisons. The Netherlands bar opposes this and points out the importance of free and confidential lawyer-client communication. The Czech bar reported about the case of wiretapping of 10 meeting cells in a detention prison where defense lawyers hold meetings with their clients. And similar aspects were reported by the Lithuanian bar about meetings of lawyers with detained persons in the police detention facilities, which were subject to video surveillance. So when you see this list of complaints, it's a worrying observation that this very fundamental and important principle is not respected as it should be in the European member states. this is, you could say, it's on national level. So why do the member states make these mistakes? But I would say, no, it's not only a question of the national level. All these situations we have heard about, they are embedded in an atmosphere which is being created on EU level by not always respecting professional secrecy in the way the rule of law would require, and by promoting the use of information lawyers get from their clients. I refer to the anti-money laundering regulations and reporting obligations for tax lawyers, for lawyers regarding tax matters. But I also refer to publications where lawyers are criticized as enablers of illegal behavior, but also of legal but unwanted behavior of their clients. And there's a discussion about measures how to control these lawyers on the one hand and how to use the knowledge they get from their clients for the purposes of law enforcement on the other hand. So what can we do? I think to address these challenges and protect lawyer-client confidentiality in the European Union is crucial for legal professionals, but also for policymakers and it is crucial for legal professionals, policymakers, and civil society to work together. Only if we agree on our aim, I think we will preserve this important principle. I think we need legal protections. We need more legal protections than we have. And when we look at the diverse practice regarding the legal privilege in the different member states, for me it seems that there is a need for legislation on EU level to ensure a common practice in the EU and to set a framework for the member states to establish and reinforce robust legal ground that explicitly safeguards lawyer-client confidentiality. We need strong safeguards regarding judicial oversight. Surveillance activities require judicial oversight and authorization. This is essential to prevent abuse of power. And what we also need is, it was already touched, we need technical tools. I think we need to develop and agree on technical tools which can help to ensure confidentiality by technical means. We heard already this morning the IA development. It all goes very quickly, and I think it's in the current situation, it will be very easy to develop technical tools where lawyer and client material, emails or documents can be identified easily. And the envelope you mentioned, I think we need this envelope before law enforcement gets access to the documents. You can develop a tool, registered, monitored by bars, how and where lawyers' documents are flagged, and then when documents are seized electronically, they need not to be put in a digital envelope. They are already in a digital envelope, and they must not be part of the whole bulk of documents which have been seized. So I think it's completely outdated then that when we discuss the e-evidence regulation, we spent hours by discussing how to protect the legal privilege by rules, by if it's necessary to inform the lawyer, when, under which condition the lawyer should be informed, under which condition the provider shall have the right to refuse a production order because it's privileged material. We don't need all these rules. If we just have a rule which allows the legal profession to flag their documents, they are out of everything. And I think this is, for the future, we must use this digital development also to safeguard this right better than we are able to do it now. And finally, this morning there was already the question, how can we teach, or can we make aware, the public aware of the specific role of the legal profession? And I think regarding lawyer-client confidentiality, there should be more awareness regarding this right. And I think there's also responsibility by the EU institutions, more or less. I think the Parliament is the most problematic institution with that regard. That it has been become common to blame lawyers, as I already said, as enablers, lawyers as such as enablers, and completely overlooking that there might be individual lawyers who commit crimes, who are involved in the crimes committed by their clients, but that the lawyers as such is not a group which should be blamed. And I think there has to be a change regarding this atmosphere, this attitude by the EU institutions. They should stop blaming lawyers because otherwise how can the public know that there's such a very important principle like the confidentiality which helps each and everyone when on the other hand they read about lawyers being criminals. I think this is a big conflict, and this does not get together. Finally, to come to an end, I want to point out or turn to the issue of independence, because the lawyer-client confidentiality is a question of independence. I would say the independence of the individual lawyer and lawyer-client confidentiality is a prerequisite of independence. Lawyers who are obliged to report to state authorities are no longer independent. It's clear, independence is gone. Lawyers who are intercepted, they are not independent. Either they act as in both cases, they act as the extended arm of the state, either by reporting actively to the state or by being misused by the state as a source of information. And why is independence so important? And I want to lead your attention to one benchmark of the Venice Commission Rule of Law checklist, and that is prevention of abuse of power. And prevention in this sense requires a high level of control mechanism regarding state authorities. Prevention of abuse of power requires power in the hands of those who are not on the side of the lawmakers, the public authorities, or the state's justice system. The only institution which can guarantee this independence and at the same time has the skills to prevent the abuse of power is the legal profession. So if you want to maintain this balance, you have to maintain the independence of the legal profession, and a cornerstone of the independence is the right to confidentiality. I come to an end. I think in general, not to paint a too black painting, in general, EU legislators recognize the importance of lawyer-client confidentiality, but there are shortcomings. The EU has the responsibility to protect and to uphold this principle, to ensure justice, individual rights, and the rule of law within its member states. And it is incumbent upon us all to work diligently and to strike this balance between security and privacy, and to ensure that this fundamental pillar of justice remains intact. So thank you, and let's just use our brains how to think how we can less balance but more focus on guaranteeing this important right. Thank you.
Margarete, thank you very much for this brilliant plaidoyer, I would say, cri du cœur, if I may say so. It is not for nothing that you have been president of the CCBE, which is the voice of all lawyers in Europe. President, I would like to ask you a question. You mentioned during your speech that from your point of view there was nothing to change on the provincial on the LPP. Did what Margarete said change a little bit your opinion on that?
Of course, I look at things from a judicial perspective, and a very limited judicial perspective, i.e. when the EU, in its exercise of its investigation powers, gets so close to the criminal sphere. For example, competition law investigations, we may expect these type of investigations also under the DMA, and other types of rules which are similar to that. So when you in that sphere, I would say that we're pretty safe. What is new to me in what Margarete said is perhaps the judicial focus, the legislative focus, that one is not sufficiently aware of how legislation can impact, say, the rights of the defense. That's something, of course, which is more abstract, which surfaced in the cases, for example, the money laundering case and that aggressive tax reporting case. So that I cannot speak about that. I don't have a clear view on the legislative process. This being said, I would like to react to what Margarete said, is having hard and fast rules where you don't have an exception and where you exclude upfront balancing, that doesn't sound right. I think there are always situations which legislators have not foreseen. I think you should always have some kind of safety valve. And then when I said, for example, legal professional privilege when it comes to judicial proceedings should be the hard call, the noyau dur, should have a touch upon it. But even there, we have in the bar rules, if we hear about, for example, the fact that somebody will be killed the next day, we all know that we have to see the dean and to say something about it. So I think there's always, it's an imperfect world, but I'm aware that there should be, perhaps, what you told us, an increased awareness in the legislative process, which is indeed in a society always focused on efficiency. There is a need to be more, well, of course, I just follow what you just said, but I'm sympathetic to that argument. But in my little sphere of the action by the European institutions, I think that generally speaking, things may go wrong, like in any human process, but generally speaking, I think the European institutions, when they themselves act, are very respectful of those rights.
Before I give the floor to you, I would just like to ask a question to Mr. Guyomar concerning the balance and what Margarete said. Do you think that a balance in this area is maybe not a good thing?
C'est un débat.
It is a debate that is recurring between absolute rights and derogable rights. The Convention says, and you've said it yourself, Article 6 has a second paragraph. This is a right, removable right. And the court cannot rewrite this convention. There is a dynamic interpretation of it. It is a living text. But we have to hold to this principle. For Article 6, same thing. Access to a court, a fair trial. Those are not absolute rights. There are some derogations to it. And the founding fathers thought about this. So yes, we may have a belief that those rights need to be enshrined. We do it with some tools that we have at our hands. Of course, this is not very satisfactory because the topic here is, can we have a greater protection or better protection? Actually, I like that term, that is being translated by meilleure protection. For me, I like more the French translation of it, meilleur, rather than greater, because with this balance idea, we may protect better. So this might be a form of answer for you, this balancing exercise, which says, okay, now this is actually greater, so we may adjust things, and things may evolve, and give, in the end, a better protection. There are many infringements of Article 8. Our court has seen this many times regarding legal professional privilege. So we actually do pay attention to contemporary needs. So we need to think about those stakeholders, judges, lawyers, and we see that in Europe, there are more and more judges and lawyers that are being questioned in their work. We have to control, in the end, if a protection has been guaranteed. And you've seen there were a few cases after the one of Luxembourg, in Strasbourg also. And today, we have protection measures for lawyers. So behind this profession, there is also the rule of law that is being attacked. So let's be careful with it. I will just conclude here. Yes, meilleure protection, not by changing rights, because we are not legitimate to do it, but let's use some operations to balance things again. However, if I may, you've made a distinction between the right to legal professional privilege and the interest of the state. But that's not correct. It's public interest. And public interest are also beneficial to everyone, also the rule of law. Sometimes we speak about competing interests. And this is very crucial, because if the aim is legitimate, then it's fine. But if that's not the case, then it's not fine. But in that case, maybe we'll have to adjust things in the future. Maybe for public interest, for the rule of law, maybe we could impose a limitation. And it's the same thing. Maybe sometimes we have to protect the client-lawyer relationship, and in the same interest, sometimes we have to protect legal professional privilege. So in the end, we all work towards the same aim. I don't know if you'll be satisfied with my answer, but for meilleure protection, better protection, what we need is identify how great public interest is. But it's never easy. We have to assess things, and we have to start from scratch every single time. But there's also an essential core, the essential core where public interest is not even an excuse anymore, because the convention then just becomes a simple text, and this won't work. I'm not sure I was able to convince you, but I'm not sure we'll be able to find an answer here now.
Your answer is very interesting, and I think that there are 2 points. First of all, this is why we set some hopes in the Convention on the Profession of Lawyer. Because, of course, the European Convention on Human Rights, it was not created with a focus on the legal profession. So I think maybe this is a solution, and I'm not aware of the last wording of the article on confidentiality, but I would say regarding the wordings I saw, it's less balancing than what the existing Convention on Human Rights allows or provides for. And the other thing is, of course, you are completely right. It's not the interest of the state. Maybe I made this mistake because I'm from the country where we don't have the notion of rule of law, but we say rule of state. And there is the tendency that the interest of the state and the general interest of the rule of law is mixed or even mistaken. Yeah, so this is what I meant, but of course, what you said is right. Thank you.
Simone, je ne sais pas si on peut encore donner la parole ou je dois m'arrêter. Une question.
Non. Est-ce qu'on peut prendre un peu de questions quand même? Parce que franchement, c'est passionnant. Moi, je voudrais entendre ça. Si vous permettez, pour diffère.
Non, mais là-bas, tout au fond, j'ai quelqu'un qui a levé la main.
Yes, there's a question at the back.
Very much for this very, very interesting discussion. I think for lawyers to be able to hear such a very high level of engagement on the basic principle of lawyers is very important. My name is Claudio Cocuzza. I am the chairman of the Anti-Money Laundering Commission of the CCBE. Quick comments and a question. The comment is that the quality and the technicality of the discussion sometimes loses, if I may, the focus on what it is that we are talking about in the context of what we are protecting. Because it's a technical matter, confidentiality, but ultimately, sometimes both lawyers, judges, and policymakers lose the aim. And the aim is that we need to have a shield where citizens' rights need to be protected. So we are talking about a shield for other people outside of this room. They are the most important holder of this right. So ultimately, the level of protection of confidentiality is a benchmark for the quality of the legal system. This must be, I think, clear for us. The higher protection we have, the best legal system we have. The second point is that is there a need to a greater protection? And we have had different opinions here and luckily so. And as a chair of the AML group of the CCBE, I must say that we need a greater protection. The reform which is coming up on the single rule book on anti-money laundering, which will bring about next year the new regulation, will affect us all in introducing a different role and scope of the exception on the advisory of exemption for lawyers. So yes, we need a greater protection. The third and last point concerns, and this comes with the question as well, on the very delicate point on what Mr. van der Woude, I hope I am pronouncing it well, that was right. I've learned my lesson after 2 or 3 times. Thank you. That you said advisory, it depends. And it is in that it depends that lies the debate. Now, intellectually, I think we follow a balance. We should find a balance and so on. Even though Margarete says something different. But the point is, we need to, however, balance rights with the same quality. Access to justice is a fundamental right for the citizen. It's fundamental that, so the other balance must be other fundamental human rights, central rights. What are we balancing here? The right for the state to have a correct tax assessment so that there are not tax evaders. Of course, I can share the concern, but are they equal? Are they the same rights in terms of quality? My opinion that they are not. And therefore, balancing the exercise you were putting is very delicate, very complex, and very risky, because when you put balancing at policymakers, they come in and make you balance things that they're of their interest. So my question is, how do you solve that?
I didn't quite... sorry, your last comment, the very last sentence. Could you please repeat that?
In the balancing exercise,
Yeah.
There is an inherent risk because you need to balance rights of equivalent nature. And you know, I was making the example of tax and access to justice. They are not equivalent. One is a human right of a citizen, and the other one is a policy decision of a state. I think they are not equal. So the risk, I see a risk there. And my question to you is,
Yes,
don't you see the same risk?
There is a risk in any human activity and any normative activity. There is a risk. It's a human activity. You can come up with examples, as you show, where it clearly, the balance works. Say, you make an example which clearly shows that there has been a violation of the rule. You can also come up with other examples. It's an imperfect world, I think, but I think what is important is to have the state of mind that it is like that, and that you're aware of the risks you do when judges carry out their balancing exercise. I think, therefore, we should also be, I think, in Europe, pretty, say, satisfied with the degree of judicial protection we have. Of course, it's imperfect, can always be changed. And it takes sometimes a very long time before cases end up in Strasbourg or before the Court of Justice or before constitutional courts. But you cannot regulate everything in the abstract. I think that's impossible.
Je voudrais rajouter, parce que votre question est très intéressante. Et
I'd just like to add something. It's a very interesting question, and I'd like to answer very clearly. This is not a conflict of law in the case law of the European Court. There is a difference between the conflict of law and conflict of interest. Now, when it comes to conflict of interest, I'll come back to that later. Sometimes there's conflict of law. It's Article 10, again, Article 8 of some other legislation, for example. So here we have two equivalent rights, because you know there's no hierarchy between rights. Today, we talked about the client-lawyer relationship and conflict of interest, but there's only one right at law, the one that is protected by Article 6 or Article 8. And this is why the margin for appreciation is quite narrow, because on the other hand, there is no competing law, there is simply an interest, a public interest, which needs to weigh enough in order to justify an interference. It has to be proportional. So thank you very much for your question, because it's a very interesting one. It really gives me the opportunity to really highlight the difference between the proportionality oversight between the conflict between rights and the conflict of interests. The speaker is speaking outside of the microphone. So I would like to take a few more questions.
My name is Berit Rice-Anderson. I chaired the morning panel on the independency of which independency was that of the lawyer. But I think the question is perhaps a little bit wrong in this panel. Is there a need for greater protection? The question should be, is the protection respected? Because it's not the judiciary that is the problem. The two justices, you represent two different overnational judiciary instruments. That actually your mandate is to safeguard a certain standard of rule of law in all of Europe. And the pressure point is not from the judiciary. You are doing what you're supposed to do, balancing the conflicting clauses in the legal rules that you are administrating. The pressure point are the national jurisdictions of, first of all, implementing these rules in a proper manner, but politicians, national politicians, speaking up for why are we allowing this and this development. And that is why the narrative of the lawyer always being involved in criminal activity is kept alive, because the narrative is that this is not in public interest to have this very independent profession, and even having conversations going on with the finance sector, with criminals, that we don't know the content of. And it's the same, you know, the church or religious societies could argue the same case, as could healthcare, you know, of giving the patient total protection against the state, because your well-being and health is more important than the state knowing why you got the bullet in your leg. So it is, we are speaking about human dignity. This is about human dignity. And I agree with the former speaker that this is about protection of citizens. And it is when we see tendencies, democratic societies, this whole institution is based on an ideal of democracy. But when we see that societies become more and more autocratic, this kind of pressure develops more and more. Movements outside of state control, liberal professions that actually have a protected position to criticize government. Of course, that's where the pressure point is. I will not criticize the judiciary, and I don't have a question. This was a statement.
Merci infiniment.
Thank you very much. I believe we've reached new peaks today, and I'm really happy about that. I'll be concluding for this panel. I wanted to say many things, but I'll never reach that kind of level. So I'd rather be quiet than say anything silly. Thank you very much. It was a very interesting conversation, and I hope we'll be able to continue our discussion, dear Simone, at another opportunity, because it was really worth it. And thank you very much, because the next speakers are ready to come to the stage. Thank you very much.
Thank you, Dominique. We will go.
To go first.